The moment Melania Trump's legal team filed a motion to compel discovery in a civil case, most people aren't even watching, something shifted, not in the headlines, in the documentation, and buried in that documentation is a reference to communications that, according to sources close to the matter, directly implicate Ivanka Trump in conduct that federal prosecutors have been circling for months. Let me be clear about what we're dealing with here. This isn't speculation, this isn't partisan noise, this is about documents, timelines, and the kind of legal exposure that doesn't go away just because someone hopes it will. So what exactly happened and why does it matter? Start with this. Melania Trump has been involved in a quiet but significant legal dispute over financial arrangements tied to her work during and after her time as First Lady. The details of that dispute have been mostly sealed, but in recent filings, her attorneys made a strategic decision. They demanded the production of internal communications from the Trump Organization dating back to 2016, and they named specific individuals whose correspondence they want to see. Ivanka Trump is on that list. Now, you might think this is just typical legal maneuvering. Lawyers ask for documents all the time. But here's what makes this different. The communications Melania's team is seeking overlap directly with a period that is already under federal scrutiny. We're talking about financial transactions, foreign payments, and potential violations of the Foreign Corrupt Practices Act. And according to multiple sources familiar with the matter, those communications include discussions about deals that were never properly disclosed. Let's talk about what that means in practice. The Foreign Corrupt Practices Act is very specific. It prohibits U.S. citizens and companies from offering, paying, or authorizing payments to foreign officials to obtain or retain business. The penalties for violations are severe. We're talking about criminal liability, and the statute doesn't care if you're a former first daughter. It doesn't care if you were acting in what you thought was a gray area. It cares about the conduct. What Melania's filing suggests is that there were arrangements made, possibly involving foreign entities that Ivanka had direct knowledge of and possibly facilitated. And if those arrangements weren't disclosed, or if they involved payments that crossed legal lines, that's not a political problem. That's a criminal problem. But let's step back for a moment. Why would Melania's lawyers want these documents? This is where it gets strategically interesting. Melania is not trying to take down Ivanka out of spite. She's trying to protect herself. And the way you protect yourself in a case like this is by showing that decisions you made, money you received, or roles you played were directed or influenced by others. You shift the focus. You create a paper trail that shows you weren't the architect, you were the participant. And if that paper trail leads to Ivanka, so be it. Now, federal prosecutors have been looking at the Trump Organization's financial dealings for years. We know this. What we didn't know until recently is how much of that investigation has been quietly focusing on the intersection between official government roles and private business interests. Ivanka held a formal position in the White House. She also maintained financial stakes in family businesses. Those two things are supposed to be separated by very clear ethical and legal walls. The question prosecutors are asking is whether those walls existed, and more importantly, whether they were breached. Here's what we know from public filings and credible reporting. During her time in the White House, Ivanka Trump continued to receive payments from Trump Organization entities. Some of those payments were tied to licensing deals, some involved foreign partners, and some of those foreign partners had business before the U.S. government. That's not illegal on its face, but it becomes illegal if there was a quid pro quo. It becomes illegal if foreign payments were made to influence policy. And it becomes illegal if those payments were concealed or misrepresented. The documents Melania's team is now demanding could show exactly that. And this is where the timeline becomes critical. Between 2016 and 2020, there were multiple instances where Ivanka Trump met with foreign officials in her government capacity. Some of those same officials represented countries where the Trump Organization was pursuing deals. In several cases, those deals moved forward after meetings that Ivanka attended. Coincidence? Maybe. But prosecutors don't believe in coincidences. They believe in evidence. What makes this moment particularly dangerous for Ivanka is that Melania's legal strategy doesn't depend on proving a crime. It just depends on exposing the communications. Once those communications are part of the record, even in a civil case, they become accessible. And if federal prosecutors see something in those communications that warrants further investigation, they can act. They don't need Melania's permission. They don't need a referral. They just need probable cause. Now let's talk about what happens next. If the court grants Melania's motion and those documents are produced, We're looking at a very narrow window before this becomes a much larger story. Legal experts I've spoken with say that the kind of communications being requested would typically include emails, text messages, and internal memos. And if any of those communications show awareness of legal risk or attempts to conceal transactions, that's devastating. Because here's the thing about white-collar criminal cases. They almost never hinge on a smoking gun. They hinge on a pattern. They hinge on knowledge and intent. And the way you prove knowledge and intent is through communication. What did you say? What did you know? And when did you know it? If Ivanka's communications show that she knew certain payments were problematic or that she took steps to avoid disclosure, that's intent. And intent is what turns a regulatory issue into a criminal case. But there's another layer here that's worth considering. Melania's willingness to go after these documents suggests she believes they exist, and it suggests she believes they're damaging. Otherwise, why risk the blowback? Why risk the family drama? Why risk the political noise? The answer is simple. She's protecting herself. And the best way to protect yourself in a situation like this is to make sure everyone understands you weren't the decision maker. Now, Ivanka's legal team has been quiet on this. They haven't responded publicly to the motion. They haven't issued statements. And that's telling, because in a situation like this, silence is often strategic. You don't want to say anything that could later be used against you. You don't want to create new evidence. But silence also creates a vacuum. And in that vacuum, the speculation grows. What are prosecutors thinking right now? What are they seeing in the documents they already have? And how does Melania's filing change their calculus? Here's what I think is happening. Federal prosecutors have been building a case quietly. They've been gathering financial records, interviewing witnesses, and mapping out transactions, but they've been missing a key piece. They've been missing the internal communications that show intent. They've been missing the proof that the people involved knew what they were doing was wrong. Melania's filing might just hand them that proof. And if it does, the exposure for Ivanka is significant. We're not talking about fines. We're not talking about settlements. We're talking about potential indictment. We're talking about the kind of legal jeopardy that doesn't end with a plea to a lesser charge. Because when you're dealing with foreign corruption statutes, the Justice Department doesn't mess around. They go hard and they go public. So where does this leave us? We're at a very specific moment. The legal machinery is in motion. Documents are being demanded. Courts are going to rule. And once those documents become part of the record, the consequences are out of anyone's control. For Ivanka, this is no longer about managing a narrative. This is about managing a legal defense. And the problem with a legal defense in a case like this is that it requires you to explain things that are very hard to explain. Why did you take that payment? Why didn't you disclose it? Why were you meeting with that foreign official while your family business was negotiating a deal in that same country? Those aren't easy questions, and the answers matter. For Melania, this is a calculated risk. She's betting that exposing Ivanka's role will insulate her from liability. She's betting that the documents will show a chain of decision-making that didn't start with her. And she's betting that the court will see her as someone who was following instructions, not giving them. That's a reasonable bet, but it's still a bet. And for federal prosecutors, this is an opportunity. They've been patient, they've been methodical, and now they might be getting the evidence they need to move forward. What happens next depends on what's in those communications. If they're benign, this story fades. But if they show what Melania's legal team seems to think they show, we're looking at a very different situation. We're looking at a former first daughter facing serious federal charges. We're looking at a family that's already fractured, becoming even more divided, and we're looking at a legal process that, once it starts, doesn't stop just because it's uncomfortable. This is the kind of story that unfolds slowly, but it unfolds inevitably, because the law doesn't care about your last name, it doesn't care about your connections, it cares about the facts, and the facts, it seems, are about to come out.